This are Joey Jackson, a CNN legal analyst and criminal defense attorney, as well as Shan Wu. He's a defense attorney and federal prosecutor. Gentlemen, thank you so much for joining me today. Joey, I want to first go to you. As you heard Sarah there saying, the jury requested to see that video, that moment that Ahmaud Arbery was killed. They wanted to watch it 3 times. They also wanted to listen to the 911 call. What does that tell you about what this jury is thinking on this second day of deliberations?
Yeah, a couple of things, Alex. Good to be with you and Shan. Listen, when you look at the actual tape, what does that do? It takes you to the actual event. And when you're looking at that, you're looking at the issue of self-defense. And so you wonder whether or not the jurors are focusing in on, there's been a lot of discussion about whether the self-defense was justified or not, right? That's a major basis. When you look at that, you examine, are the jurors asking, was there provocation on the part of the defendants? In the event there was provocation, guess what? You're not entitled to self-defense. Were the defendants committing any felony, aggravated assault, right? When you use your trucks in order to assault Mr. Arbery, that would be a violation, and therefore you would not, in commission of that felony or false imprisonment, get the benefit of self-defense. Then finally, if you're the initial aggressor, you wouldn't get that. Also, Alex, I'm kind of thinking that if they got even to the issue of self-defense, whether it means the jurors have concluded that this citizen's arrest law would be applicable. The prosecutor spent a whole lot of time saying there's no applicability. There was no crime committed that they had immediate knowledge of, and certainly one not committed in their presence. So why were they even chasing him? It wasn't a felony which would allow them to chase him. So as I assess and look at that, you have to wonder whether they're focusing in on that issue, and when they do, last point, is it as to one particular defendant? Is it as to another defendant? Have they made a decision as to one and are parsing out what the conduct of was the others? But they're honing in on the central issue of the case, that's for sure.
Shan, I want to ask you a little bit more about this 911 call. The jury asking to hear part of that call that was made by the defendant, Greg McMichael. He's the father. He was in the bed of that pickup truck. But the jury only wanted to hear the very beginning of the call where the dispatcher asks, what's your emergency? And you can hear Greg McMichael saying, quote, there's a black male running down the street. Why would they want to listen to just that part?
Well, that really goes to the heart of the case, doesn't it? Because the whole point here is what motive do they have to think there's a crime? What motive might they have in terms of racial animus? That was a very powerful moment because the dispatcher is saying, what's your emergency? The emergency? Black guy running down the street. Not really an emergency, racial motive there. So it's very important that they're looking at that. I have to say, I agree with Joey. It's an interesting juxtaposition here. If I were the prosecutor, one, I don't like holiday verdicts as a prosecutor. People are feeling kind of generous. They're feeling pressured. But if I'm the prosecution here, I don't want them looking at that last moment where there's this struggle and encounter because that does go towards self-defense. I want them looking at what led up to that. I would like them to be asking to review the evidence about how they followed him, how they boxed him in the earlier encounters, because that's the big picture of them being the aggressors, planning to find him, to hunt him down, to trap him that way. But on the other hand, when you juxtapose that moment, which is self-defense, with the 911 tape, you know, they're looking at the 2 crucial moments in the case. Also, I would say Joey's analysis of how they're deliberating, I would concur with. It looks like they're being pretty methodical because for them, they have to think about self-defense, obviously. And it might be a good sign for the prosecution that they're looking so intently at that because it may mean that, look, obviously there's a death here or shooting death. They may have already decided that they've met elements for some of those felonies and they need to really dive in and see if self-defense overcomes that or not.
Yeah, Joey, I do want to ask you to sort of get inside the minds of these jurors because this is a complicated verdict sheet. You have these 3 defendants, 9 counts for each defendant, 3 lesser charges for William Bryan. They each obviously had distinct roles in this killing. How do you think this jury is working through this very long list of charges?
You know, it's interesting, a great question, Alex, because the prosecutor really laid out the narrative that she would want them to buy into. And when I say that, she was really a professor when she gave her closing argument as well as her rebuttal. And if you're looking at it and you're a juror, from her perspective, she went through the elements. Ladies and gentlemen, let me tell you what citizen's arrest means. Do you see a crime? Right to Shan's point, they're not looking at things leading up to this, which leads me to conclude, you know, did they conclude that citizen's arrest was applicable here, such that they're honing in on the specifics of self-defense. If they've gotten to that part, then you're going to ask questions. At the time that there was this, fatal shots, was there immediate fear of death or serious bodily injury? Were the shots fired proportionate to any threat posed? Did, in fact, the defendant at that time act reasonably under those circumstances? And then, to your last point, Alex, to your level of complication, even if they make those conclusions, now they have to go back and say, well, wait a second, he might have been in immediate fear at the time, and he might have, in fact, acted proportionally. But wasn't he the aggressor? And didn't he provoke the attack? And wasn't he engaged in other felonies such that we shouldn't give him self-defense? So a lot of questions to be asked if they're following those jury instructions, and of course we believe they're doing just that.
All right, gentlemen, we got to leave it there. Joey Jackson, Shan Wu, thank you so much for breaking that down. I know you'll be watching this very closely in these final hours or days of this trial.
Thanks, Al.